Think about the last time you bought a gun, or thought about buying one. Somewhere in that process, there was paperwork, maybe a background check. And if it was a certain kind of firearm, a suppressor, a short-barreled rifle, a machine gun, there was something else waiting for you. A $200 tax, a federal registration form, and a wait that could stretch for months. It feels like it's always been this way, like the federal government has always kept a ledger of who owns what, always taxed certain weapons differently than others, always drawn these particular lines. But here's the thing, for almost 150 years, none of that existed. Not the tax, not the registry, not the federal license, nothing. A father could walk into a hardware store and buy a fully automatic weapon the same way he'd buy a shovel. No form, no waiting period, no federal agency tracking the sale. A teenager could mail order a machine gun through a catalog and have it delivered to his front door. There was no federal firearms law at all, not one, governing what an American citizen could own. This is not just a story about guns. It's a story about how a nation with almost no federal oversight of weapons, of any kind, arrived, in the span of a single generation, at a system of taxes, registries, and federal tax stamps. It's a story about what has to happen, historically, before a government decides it needs to know what its citizens are holding. So let me take you back to the beginning, to a country where the government simply didn't ask. To understand how strange the pre-1934 landscape really was, you have to set aside everything you think you know about how guns work in America today and start from zero. There was no federal license to sell a firearm. There was no federal registry of who owned what. There was no federal tax on the manufacture, sale, or transfer of any weapon, whether it was a hunting rifle passed down through a family, a handgun bought for protection, or a fully automatic weapon capable of firing hundreds of rounds a minute. For the first century and a half of the Republic's existence, the federal government simply had no apparatus for any of this. Not because it had considered the question and declined to act, but because, for most of that time, the question had never seriously been asked. Firearms in early 20th century America moved through commerce the way any other manufactured good did. Hardware stores sold rifles and shotguns beside farm tools. And according to accounts that have circulated for decades among collectors and historians, though the precise catalog pages are harder to pin down than the stories suggest, mail-order retailers in the 1920s carried firearms as ordinary merchandise, delivered by parcel post the same way a plow blade or a bolt of fabric would be. Even a weapon as formidable as the Thompson submachine gun, the Tommy gun that would soon become the signature weapon of Prohibition-era crime, could, for a stretch of roughly 10 years after its release in the early 1920s, be purchased with no federal license, no background check, and no paperwork of any kind. Its main obstacle wasn't the law, it was the price. At $200 to $250, a Thompson cost roughly half as much as a brand new Ford automobile, well beyond what most working Americans could justify for a firearm. This wasn't a loophole, it wasn't a gap that somebody had simply failed to close. It was the default condition of the country, because in a nation whose founding generation had spent the better part of a decade fighting a war against a distant government's standing army, the idea of that same government now keeping a ledger of its citizens' weapons would have struck most Americans as a contradiction of the very reason the country existed. By the time you reach the turn of the 20th century, this unregulated landscape hadn't changed in any fundamental way, but the country around it had. Cities were growing at a pace the founders could never have imagined. Manufacturing had transformed what a firearm even meant. The single-shot muskets of the founding era had given way, over just a few decades, to repeating rifles, semi-automatic pistols, and, critically for where this story is going, fully automatic weapons capable of a rate of fire no 18th century mind could have conceived of. And here's the thing most people don't realize. None of that technological leap triggered a change in the law. The legal framework governing firearms ownership in 1920 was, in its federal dimension, essentially identical to the legal framework in 1800. No tax, no registration, no distinction, at the federal level, between a bolt-action hunting rifle and a weapon designed for sustained automatic fire. A citizen's right to walk into a store and purchase either one was, as far as the federal government was concerned, the same right. This is the paradise the rest of this story is going to complicate, not because it was simple or ideal, but because it was real, and because it lasted so long that by the early 20th century, most Americans had never lived under any other system. There was no generation of Americans in 1920 who remembered federal gun regulation because it had never existed. It wasn't a right being eroded. It was a status quo about to meet something it had never had to reckon with before. Now, to be fair to the historical record, this was not a lawless country. Cities and states had been writing their own rules about weapons for generations. Some of those rules were old. Some were about to get a lot more serious. Take New York. In 1911, the state passed what came to be known as the Sullivan Act, named for State Senator Timothy Sullivan, requiring anyone who wanted to carry a concealable handgun to first obtain a license from a local magistrate. It came after New York City's mayor, William Gaynor, was shot by a disgruntled former city employee in 1910, and after a separate, widely reported killing near Gramercy Park. Carrying a concealed pistol without a license became a felony. The law passed the state Senate 46-5. New York wasn't unique. States and cities across the country, from the years after the Civil War through the early 20th century, had been passing their own licensing requirements for carrying weapons. Dozens of states, in one form or another, by the time the Sullivan Act made national headlines. Here's the thing most people don't realize. None of this was federal. Every one of these laws, Sullivan's included, was a state or city rule, enforced by state or city police, answerable to state or city courts. If you crossed a state line, that license meant nothing. If your state had no such law, nothing stopped you. The federal government, watching all of this unfold, did not pass a single firearms law of its own. Not a tax, not a registry, not a license. For Washington, the entire question of who could own what kind of weapon remained, as it had been since the founding, somebody else's problem, a state matter, a city matter, anything but a federal one. This is the paradox worth sitting with for a moment. America wasn't a country with no rules about guns. It was a country where the rules, such as they were, stopped at the state line, and where the federal government had never once stepped into that space, for any weapon, of any kind, including ones that could fire hundreds of rounds a minute. That absence was about to collide with something the country hadn't seen before: a nationwide, coordinated criminal enterprise, wealthy enough to buy the most advanced weapons on the market, and operating across every one of those state lines the old licensing laws couldn't reach. In January of 1920, a new law took effect that would, within a decade, turn that quiet gap in federal law into the center of a national crisis. At 1 minute past midnight on January 17, 1920, it became illegal to manufacture, sell, or transport alcoholic beverages anywhere in the United States. The 18th Amendment had been ratified the year before. The Volstead Act was the law that gave it teeth, and within the hour, literally within the hour, the first documented violation was already on the books in Chicago. That detail alone tells you almost everything you need to know about how this was going to go. The federal government had just outlawed one of the most widely consumed products in American life, and it had done so with almost no capacity to enforce that ban. In Illinois, Iowa, and parts of Wisconsin combined, a stretch of the country that included Chicago, one of the largest cities in America, the Federal Prohibition Unit had exactly 134 agents to cover it all. Chicago's own police chief at the time, Charles Fitzmaurice, would later admit that 60% of his force was, in his words, in the bootleg business themselves. Into that vacuum stepped organized crime, not as a new invention, but as something that scaled up almost overnight into a form the country had never seen before. Bootlegging alcohol required exactly the kind of infrastructure organized criminal syndicates were built for: distribution networks, corrupted officials, and the willingness to use violence to protect territory. Al Capone's Chicago operation alone was, by some estimates, pulling in $60 million a year. an almost unimaginable sum for the era, built entirely on a product that, 5 years earlier, had been legal to sell on any street corner in America. And the human cost showed up immediately in the numbers. A study of more than 30 major American cities found that in the first 2 years of Prohibition, overall crime rose by 24%. Homicides were up 13%. Assaults were up 13%. This wasn't a marginal uptick, it was a measurable, documented surge in violence, tracking almost exactly with the years Prohibition was in effect. Here's the thing most people don't realize. The crime wave wasn't really about alcohol at all, not by the late 1920s. Alcohol was just the product. What Prohibition had actually created was something new in American life, a nationwide criminal economy, worth hundreds of millions of dollars, with the resources to arm itself however it saw fit. And in the mid-1920s, however it saw fit increasingly meant a weapon that had, until then, mostly been a military curiosity, a fully automatic submachine gun capable of firing hundreds of rounds a minute, legal to purchase with no federal paperwork of any kind. The stage was set, the money was there, the weapon was legal, and the men willing to use it were about to make sure the entire country noticed. The weapon that would come to define this era had a name its inventor never intended for the underworld: the Thompson submachine gun, developed by a retired Army brigadier general named John T. Thompson, who had originally hoped it would end trench warfare in the First World War. It arrived too late for that war. Instead, it found a different one. Thompson's company marketed the weapon, quite earnestly, under the slogan, "On the side of law and order." It was pitched to police departments and to the U.S. Postal Inspection Service, which bought some of the earliest units to guard mail trains against robbery. But at $200, a steep price for the era, it wasn't police departments who ended up buying most of them. It was the bootleggers, who had the Prohibition-fueled cash to afford exactly the kind of firepower a rifle or a handgun couldn't match. The gun's criminal debut, according to newspaper reports from the time, came on September 25, 1925, when a Chicago bootlegger named Frank McCurlane used one in an attempt on a rival. Over the next several years, it became the signature weapon of gangland Chicago, earning nicknames that tell you exactly how the public came to see it: the Chicago typewriter, the chopper, the Chicago piano. Names given with a kind of dark humor by a public that was, at the same time, increasingly terrified of what the weapon represented. Then came the morning of February 14, 1929. In a garage on Chicago's North Side, in the Lincoln Park neighborhood, 4 men, 2 of them carrying Thompsons, lined up 7 members of a rival gang against a wall and opened fire. 7 men died. The incident became known as the St. Valentine's Day Massacre, and it did more than any single event to fix the Thompson submachine gun in the American imagination as a weapon of pure, cold-blooded slaughter. But it wasn't the only incident that mattered, and in some ways, a smaller, less famous one may have done more to turn public sentiment toward actual legislation. On July 28, 1931, in New York City, a drive-by shooting using Thompson-style weapons aimed at a rival gang member on a crowded street wounded 4 children and killed a baby. The press called it the Baby Massacre, where the St. Valentine's Day killings were gangster-on-gangster violence that, however horrifying, stayed within the underworld. This was different. It was ordinary bystanders, children, caught in fire from a weapon that had no business being that easy to obtain. Here's the thing most people don't realize. For all its infamy, the Thompson was never as common among criminals as Hollywood would later suggest. Most gangsters, historians note, still preferred a concealable pistol or a sawed-off shotgun for actual killings. Quieter, easier to hide. But the Thompson didn't need to be common to change the conversation. It needed to be visible, spectacular, and terrifying exactly often enough. And by 1931, after a decade of Prohibition violence capped by headlines like the Massacre and the Baby Massacre, it had done exactly that. The public wasn't just uneasy anymore. It was demanding that somebody in Washington do something about a weapon that, as far as federal law was concerned, remained as legal to buy as a shotgun. By the early 1930s, the pressure on Washington had become impossible to ignore. Gangland killings were front-page news across the country. Names like Al Capone, John Dillinger, and Bonnie and Clyde weren't just criminals. They were national celebrities, chased by newspaper headlines as much as by the police. And the weapon that kept showing up in the most sensational of those headlines was the Thompson submachine gun. President Franklin Roosevelt's new administration decided it was time to act. The man Roosevelt tasked with the job was his Attorney General, Homer Cummings, and Cummings faced an immediate and very specific problem. How do you write a federal law restricting a weapon when the Constitution gives Washington no general police power to simply ban things state governments hadn't already banned? An outright federal prohibition on owning a machine gun risked running headlong into a Second Amendment challenge, and, just as dangerous politically, into an argument that the federal government was reaching into territory that belonged to the states. Cummings and his staff found their answer in a part of the Constitution that had nothing to do with weapons at all: Congress's power to tax. If Washington couldn't simply ban a machine gun outright, it could tax the manufacture and transfer of one so heavily that the tax itself became the deterrent. Cummings told Congress directly that this was the strategy. The administration had chosen the tax route specifically because a straightforward ban would have invited a constitutional fight it might lose. The bill that emerged, originally, went further than what would ultimately pass. Early drafts included handguns alongside machine guns and sawed-off long guns. But after direct engagement from the National Rifle Association, which in 1934 was still primarily a marksmanship and hunting organization rather than a political lobbying force, handguns were dropped from the bill. What remained were the categories most associated with the era's gang violence: machine guns, short-barreled rifles and shotguns, and firearm silencers. On June 26, 1934, President Roosevelt signed the National Firearms Act into law. It required anyone making or transferring one of the covered weapons to register it with the federal government and pay a $200 tax, a figure set, according to the congressional hearing record, to roughly match the retail price of a machine gun at the time. Adjusted for what a dollar was worth in 1934, that tax alone could easily exceed the cost of the weapon itself. Here's the thing most people don't realize. The National Firearms Act never outlawed owning a machine gun. It still doesn't, technically, today. What it did, and what makes this law so different from what most people assume federal gun law looks like, is make ownership a matter of paperwork, registration, and cost, rather than a matter of yes or no. It was, by design, a tax law wearing the clothes of a crime bill. The strategy worked exactly as Cummings hoped. 5 years later, when two Arkansas men challenged the law's constitutionality all the way to the Supreme Court, the justices upheld it, ruling in United States v. Miller that the tax-based approach was a legitimate use of Congress's power and sidestepping, almost entirely, the deeper question of what the Second Amendment actually protected. For the first time in the nation's history, the federal government had a foothold, however narrow, however cautiously built, inside a space it had never once entered before. By 1937, 3 years after the National Firearms Act took effect, roughly 16,000 short-barreled rifles and shotguns, 18,000 machine guns, and 700 silencers had been registered with the federal government. Compare that to what had come before: no federal registry of any kind, for any weapon, at any point in American history. In the span of 3 years, the country had gone from 0 to tens of thousands of entries in a government ledger, a ledger that, before 1934, simply didn't exist. This is the part of the story most people never connect to their own lives. The National Firearms Act wasn't just a law about machine guns and sawed-off shotguns. It was a template, a proof of concept for how the federal government could regulate firearms at all, using a legal mechanism the courts had already signed off on. 34 years later, when Congress wanted to expand federal firearms regulation further, it didn't need to start from scratch. The 1968 Gun Control Act built directly on the legal foundation the NFA had established, this time reaching further, into ordinary commerce in firearms generally, using Congress's power over interstate trade rather than only its taxing power. Think about what that means the next time you fill out a form at a gun shop, or the next time you read a news story about a federal firearms case. None of that infrastructure, the registration systems, the federal paperwork, the very idea that Washington keeps records on certain weapons, existed before a specific Tuesday in June of 1934. It's not ancient. It's not something the founders debated and decided. It is the direct, traceable descendant of a law written by a small group of Justice Department lawyers in response to a specific and violent decade, using a legal loophole nobody had thought to use quite that way before. And here's the thing most people don't realize about how it was received at the time. The National Firearms Act did not spark the kind of national argument that gun legislation sparks today. Public opinion, worn down by more than a decade of headline gang violence, was largely supportive. The NRA itself, at the time still focused on marksmanship and sport shooting rather than legislative combat, negotiated changes to the bill rather than opposing it outright. It would take decades and a very different political culture before federal firearms law became the flashpoint it is now. That contrast is worth sitting with, without drawing any conclusion about which era got it right. The 1934 Congress wasn't operating from some abstract theory of rights or a state's proper reach. It was responding, in the most direct way lawmakers know how, to a specific, documented wave of violence connected to a specific, documented weapon. Whatever you think about firearms regulation today, the federal framework you're familiar with didn't arrive as an inevitability. It arrived because prohibition ended in gunfire loud enough that a Congress with almost no prior involvement in the subject decided it needed a foothold, and found one through the tax code that has never really let go. So here's where this leaves us. The world before 1934 was not some libertarian paradise, ruined by an overreaching government. It was a country that had simply never been asked the question until prohibition armed criminals with weapons no state or city law was built to handle, and until a specific string of headline violence, culminating in massacres that killed strangers and children alike, made the question impossible to avoid any longer. This isn't a simple story of freedom followed by control. It's a story of a government encountering a problem it had never faced before, and reaching for the only constitutional tool it was confident would survive a courtroom. And that's really the deeper thread running through this whole channel, isn't it? The federal government you interact with today, every tax form, every registry, every regulation that feels like it's just always been there, almost always has a birth date, a specific year, a specific crisis that made it necessary, or at least made it possible. Nothing about the current shape of federal power was inevitable. It was built, piece by piece, crisis by crisis, and the National Firearms Act is one more piece of that same, much longer story. If this is the kind of history you didn't learn in school, the quiet, documented origin stories behind the systems we take for granted, hit that subscribe button. This channel exists to keep finding these moments and laying them out plainly, without the noise. And I want to ask you something, because I think you'll have a real answer. Knowing that this entire framework traces back to one specific decade of crime and one specific piece of legislation, does that change how you think about it? Not whether it's right or wrong, just whether it feels different, now that you know where it came from. Tell me in the comments. If you liked pulling on this thread, there's another one sitting right next to it. We told the story of how the United States used real, tangible money for nearly 200 years, and the specific year everything about what money even means quietly changed. It's called America Had Real Money Until 1971. What do we actually use now? And if you want to keep tracing these hidden turning points in how this country actually works, that's exactly where to go next.